All right, everyone, let's get started. It looks like the attendee numbers are slowing down as they're increasing here. So I think that we can get going. Welcome to the HOA Information and Resource Center's HOA forums. Today's topic is going to be self-managed HOA guidelines. General purpose of this presentation is to provide tips and guidelines and even some considerations for self-managed associations or those associations that are considering switching to being self-managed. Joining me today, well, my name is David Donnelly, and I'm the HOA Information Officer. And with me today as a panelist is Amanda Lopez, the HOA Information Support Specialist. No doubt many of you have reached out to Amanda for your various questions regarding the registration process, and I'm pleased that she's here with me today as well.
Thank you, David. And good afternoon to everybody, and thank you for attending.
So, as always, here's our friendly legal disclaimer. The Information Office is not able to provide legal advice, and therefore the information that's being provided in this presentation today is for educational purposes only and is not meant to provide, nor should it be construed as legal advice. For those of you that have reached out to the office before, we often do say, make recommendations that you reach out to a qualified Colorado licensed attorney for specific legal questions. The HOA Center, as some of you certainly know, was created in 2011 by statute and was then renewed 4 years later. Currently, the statutory scheme that allows our office to exist is very express regarding what the HOA Information and Resource Center can and cannot do. As many of you might know, the HOA Center only provides information to homeowners regarding their basic rights and responsibilities under the Colorado Common Interest Act. You may hear me refer to that herein as CCIOA or as Kiowa. It's pronounced like the city or the Indian tribe, but that stands for the Colorado Common Interest Ownership Act. We gather and analyze reports and information through complaints and HOA registrations. We create resource materials for the public. We provide education and forums such as this. We provide a website, which I highly encourage all of you to visit if you have not visited in the past or recently. We are currently, always we are working to update that with most pertinent types of information that and based on the types of questions and inquiries that Amanda and I receive here in the office. Most importantly, we provide an annual report to the Colorado legislature. That information that we provide to the legislature is dependent on you, the public, both as board members and homeowners. That means complaints that you submit to our office are very important to provide guidance to the legislature so that they can in fact make educated and informed proposals for new legislation. Many of you no doubt know about the legislation that became effective just 2 days ago. And in part, that laws such as that are a result of the information that our office collects and provides to the legislature, in addition to other sources, of course. It's not the only source, but it's an imperative and a very important part of the calculus that the legislature uses on an annual basis to draft and prepare and propose and pass new legislation in the state of Colorado. What we do not do in the HOA Information and Resource Center is we are not a regulatory program. We do not mediate. We cannot provide legal advice, as I mentioned earlier, and we are not an advocate. We cannot assess fines or penalties. nor can we enforce the HOA's failure to register or other aspects of HOA's issues that are brought to our attention. So today, we're here to talk about self-managed associations. And so while this presentation is primarily prepared for board members and maybe even community managers, of course, this presentation is open to all of the public, whether that's someone that is merely an interested unit owner within an association, or of course, even if you don't own a property and maybe you're just interested. But again, this presentation is gauged particularly towards you board members out there. Self-managed communities are really a small minority of the associations out there. The data that's been collected by our office through the end of 2021 had about 6,390 actively registered associations that were professionally managed, whereas we only had about 1,622 that were reported as self-managed. That's basically an 80-20 split, with 20% of those actively registered associations in the state of Colorado being self-managed. Many of you here, no doubt, are exactly that. But an important clarification that I'd like to address, and I think you'll hear about me bringing this up a few times throughout the rest of the presentation, is that a lot of associations out there could be identified as maybe more of a hybrid management. And what this would do would be where a board would delegate specific responsibilities, but retains other responsibilities themselves. A great example would be accounting, sending notifications out, doing accounts payable, accounts receivable, paying your vendors, receiving assessments from your property owners. That would be something that might be outside of the wheelhouse or the skill set of you as board members. And but other than that, you feel very confident that you'd be able to manage vendors and deal with architectural control, design change requests, and other complaints. That would be a great example of where we would really identify you more so as a hybrid management style, wherein you're using some professionals for certain aspects of your board management, but not others. If you decide that you might want to go down this path, assess carefully the management skills that each of you board members specifically have. I think that's an important aspect for you all to consider if you believe that hybrid management might be appropriate for your community. Community association managers, and we refer to those in the industry as CAMs, CAMs, are not licensed in Colorado. Yes, many of you remember a time when they were, and that time was from January 1st, 2015 through June 30th of 2019. During that period of time, we had a robust CAM management program in place where licenses were issued, enforcement actions were taken, and it was a successful program by all counts. But in 2019, when the CAM program was up for renewal, it was not renewed. Therefore, in early 2022, a bill was proposed which would have created a really robust dispute resolution program for HOAs in the state of Colorado. It included language that pertained to CAM management, CAM licensure once again. But unfortunately, language was removed from that bill, and therefore that language was not part of what eventually was passed by the Colorado legislature. Then most recently in 2022, another bill was proposed which would have initiated CAM regulation once again, but that bill did not get past committees and it was postponed indefinitely. That bill was HB 1239 if you are interested in looking that up. And anyone that is interested in that, I recommend that you take a look at the Colorado General Assembly website. If you were to simply web search for the Colorado General Assembly, that's the website for the first hit that you will get is the website for the Colorado legislature. And you can look up bills that have been proposed and whether those bills passed or not, and you can look at the history of those bills, the drafts as they worked their way through the legislature. Might be, if this is of interest to you, looking at HB 22-1239 might certainly be a good idea for you. This is one of the most important slides in my opinion. It's high level. Many of you are going to look at it and say, this is common sense, David. Why put it here? The reason I'm putting this slide in this presentation is because I think that it is one of the most important things that, whether you're self-managed or professionally managed, board members should remind themselves of on a regular basis. Every community I know is different, but success and success can be different in each of those communities as well. But I think that I believe firmly that if you adhere to these rules, you will find success in your communities. If you put your community first, if you communicate openly and regularly with your unit owners, if you develop and share a vision for your community, particularly with your fellow board members, but also share that vision with your unit owners, build community support, build the opportunity to fulfill a vision for what your community could be, a safe, clean, welcoming environment, whatever the case might be for your community. That's what I want you to think about as board members so that you can take your community level to the next, your community to the next level. And finally, always remember that your association is a business. You are a corporation filed under Colorado laws, and as many of you know, you are registered with the Colorado Secretary of State in addition to being registered with the Colorado Division of Real Estate. And so keeping in mind that you're a business, that means act professionally. Don't act on emotions. Enforce rules uniformly across all of the community. And if you maintain your property records and share those records with the unit owners, that is a sure sign of a road to put you on the road to success within your communities. The more you're transparent, the more you effectively communicate with your owners, the better that and the smoother your communities will run. Some of you here might have very specific reasons why you want to be self-managed. And so this isn't an exhaustive list. I know that, and you can recognize that easily, but different communities have lots of different reasons why they would maybe want to be self-managed, and just as much reasons why you might say, whoa, this is too much of a commitment for us as a board. We need professional help. It's these reasons are the same, maybe some of the same reasons why you might say why I should be a professionally managed community, but maybe it's your community size. If you're 6 units and you simply don't have the dollar amounts that in order to afford paying a professional company. Maybe you're in a remote location. Colorado's a very big state. Colorado, it has lots of very rural areas, and there aren't necessarily CAM management within a stone's throw of your properties. Some communities, of course, need someone on site much more regularly, maybe almost full time. Others need someone on just to come by and do a site visit once a week. But if you are in certain parts of the state, getting someone to come by once or more a week might be a challenge for you. So consider where you're located in the state is an important consideration. A lot of you very well might just be saying, I want to be self-managed because I can't work with my CAM anymore. I have too many issues. They tell me how it is, and aren't open-minded to what our vision as a board is. That maybe they're trying to do a one-size-fits-all to them, their management style, and that doesn't fit with what your goals are for the community. Many CAMs are, of course, very accommodating to that, and they want to understand that. And I think most vendors are, but sometimes you just if you can't find the fit with your vendors, be it a CAM or an attorney for that matter, self-management is an option. I mentioned earlier when it comes to community size, community costs is also an important consideration. We have costs that are skyrocketing in some cases, but nevertheless, they are increasing across the board in the state of Colorado and nationally and worldwide right now. Is going self-managed maybe an option where you, the board, can save some costs with a little bit of extra time, a little bit of extra effort from you? Can becoming self-managed be address that issue of you're needing to save costs? I mentioned when you have frustrations with your CAM, independence and freedom of choice are right in line with that. If you feel that your CAM is trying to push your community in a particular direction and you're not happy with that, freedom of choice and independence is an important consideration, so that you guys as board members can dictate what this community is working towards and what it should look like. If you want to be as open and as transparent as you can be as a board, so that your community knows what's going on, knows when your meetings are, has the opportunity to be heard at those meetings, but your CAM might say, well, I don't want to be here for 6 hours for a board meeting. There you go. And again, this presentation is not to besmirch or speak ill of CAMs. CAMs are an important and in many cases a vital participant in management of so many associations across the state. But these are things to consider, and always when we're talking about these next few steps on the couple next slides here, think about hybrid management. Can I do that? Can we do that as a board? Or do we need expertise, outside expertise, to assist us with that? Whether that's finding vendors, whether that's writing notices of violation, whether that's updates in the law, whether that's a myriad of other things. Keep that notion of hybrid management in the back of your mind, so that you can always know that that's a possibility. And because you as board members get to negotiate and contract with management companies as you see fit, so for the services that you want. Think of it as an a la carte menu. In many cases, not every management company out there is going to offer an a la carte selection, but many of them do. And they say, we specialize in accounting services and we leave some of these other services to you, the community. And guess what? That's going to save you $1,000 a month, or whatever the numbers might be. I don't know what those numbers are, but you can chip away at your costs as necessary, if necessary, as you're going through this process. So these next few slides are going to be some high level but I think important considerations for each and every one of you. We're going to talk about what the duties are for a board member, what the qualifications are for a board member, and where you're going to find those qualifications in your governing documents. We're going to talk about whether board members can be compensated, and we're going to talk about an ever important question that we hear a lot about here in the HOA Information and Resource Center. What's my liability as a board member? Can I be sued personally? Can people come after my home for the services that I'm providing to this community on a volunteer basis? We're going to talk about that. And then finally, What are the time commitments? Clearly, as we've talked about here, I think you can gather that time management or time commitments are going to be greater if you're self-managed than if you're professionally managed, because your CAM is going to take care of some of that load on their time. You're paying them for that, but they're going to be able to help you, and that makes it so that they're gonna do the back end work, and then they're going to provide you a recommendation as a board, and you can vote on the appropriate action based on your board's decision. But it's important that no matter what your management style is, you as board members are the buck stops with you. The responsibility stops with you. So you don't get to simply defer to the management company and say, they do it, I don't know about it, I don't want to know about it. That's not permissible. You have certain duties, and those duties that we're going to talk about now are really important that you understand. You have the ultimate responsibility. A CAM can only make recommendations of action. A CAM cannot vote on your behalf. A CAM cannot make a decision. A CAM cannot unilaterally elect someone to a vacant board space. The board has certain responsibilities, and they have to act on those. And more often than not, you should be making a written record of those decisions along the way. Maybe it's a board's resolution in writing and signed by your secretary. Maybe it's hold a special meeting and vote on an issue after you've heard from the community that attends that meeting and wants to talk about that issue. And then you create minutes of that meeting. These are community records. Every decision, every action that is made by your board should be reflected in a writing, in a minutes or a corporate resolution, or at least in emails that can be discovered and inquired upon and copied and viewed by your unit owners. Remember those things as we're talking about these duties as we go through. The duty of care is important here. Every board member has a responsibility and must act with a reasonable standard of care. I can't tell you how a judge is going to rule on reasonableness, but I think that in most cases, if you were just talking with your friend and you said, what's reasonable here? That's a fair standard. Think about it from, if it was being done to you by a different board, is that reasonable? It's hard when you're saying, of course it's reasonable because I'm doing it. But you got to take a step back and look at that and be careful to think about how this will look to an uninterested party, a judge, your lawyer, so that your lawyers can advocate properly and effectively for you. Take that step back and look at your actions from that perspective. You also have a duty of loyalty. Every board member must place the association's interests before their own. You are serving in an important role as a board member. Yes, you might have gotten onto the board because you had a pet project, quote unquote, your interest. You might want the trash to be dealt with better, or parking is an issue. That's okay. You can have your projects. That's not a violation of your duty of loyalty. But always taking that step back and looking at it to say, am I putting the interests of the association before my own? And if you can say yes, you're on the right path. You have a duty of due diligence. Board members must conduct themselves in a manner of an ordinarily prudent and reasonable party in order to avoid harm to other persons or themselves. An example here would be, under what circumstances do you need to obtain multiple quotes? If some associations might have a handy person of some sort that comes around and fixes little tinkering things, easy things, that's okay. You can have somebody that contract for that. But what about if you need a new roof? for a townhome. We're constantly plagued with hail in our communities in Colorado, so it's a great example. Do you get one quote for a project that might cost somewhere between $100,000 and $3 million for some other associations? Or do you get multiple quotes? Acting diligently and conducting your due diligence is an important thing to remember. Don't just go to the same vendors over and over again. Don't just use the same landscaper that your community's used for the last 20 years, never shopping around, never seeing if there's a better deal out there. You might get a better deal, lower price, better service if you look for it. And so take that time. Exercising a duty of reasonable care is also important. You act on behalf of the association. And this is tied in with what I just talked about with getting quotes, thinking about how you can serve your community best. The duty of confidentiality is one that comes up a lot in our office. In particular, some of you might be familiar with HB 221137, which is a bill that just became effective 2 days ago, and that bill in particular changes the reasons under which you as board members can go into an executive session. Executive session is not to conduct regular business. It is not to vote on the landscaper. It is for express, enumerated is the fancy term, different reasons why you can go into executive session. One of those is to protect the confidentiality of your unit owners. You go into executive session now under 1137 to talk about collections and whether or not to vote to refer a delinquent homeowner who owes money to the association to a collection attorney or to a collection company. That is something that would cause reasonable embarrassment to a homeowner, and you have a duty to keep that information confidential. You don't post a delinquency notice saying, Jill in unit 204 owes us $500, and but all these other people get gold stars because they're up to date. You don't get to do that. That is a confidential matter that must be worked out. Another important and very important thing to consider is when you as board members receive confidential attorney-client privileged information. If someone is suing your board, suing your association, you will likely retain counsel, and that attorney will provide legal advice to each and every one of the board members. You have a duty to protect that information, because if you give that information away, sometimes even if it means giving it to your spouse to talk about it with your spouse, you could be violating that attorney-client privilege and it could be waived. And that can have dire consequences for the outcome of a legal matter. So keep that in mind. When you're wearing your board member hat, you keep that hat on, and remember that you have that hat on so that you can act appropriately given the circumstances. And then finally, and we'll chat about this a little bit in a moment, is you have a duty to be free of conflicts of interest. Each and every one of your boards should have a governance policy that pertains to conflicts of interest. You as board members get to define what a conflict of interest is for your community, which is a unique position that you find yourselves in. Under what circumstances do you as a board member have to recuse yourself from voting? Certainly, you can understand a circumstance where if you're a board member and you filed an architectural review for a variance so that you could paint your house a different color or put another story on your house or whatever the circumstance may be, that's something where you shouldn't be voting on it yourself. Look at each of your community's conflict of interest policies and consider how you are complying with that, and if that rule, if that policy appropriately represents your community and provides assurances to your unit owners that you are acting properly and fairly and transparently. Your governance policies are really important for that, not just your conflict of interest policy, but your other policies as well, to help your community better understand what you are doing, how you do it as a board. Let's talk now a little bit about the qualifications of the board members. Everybody on this call gets to at least say this, that you qualify to be a director pursuant to the Colorado Nonprofit Corporation Act. Why? Because the only guidance that's required by the Colorado Nonprofit Corporation Act is that you're an individual. So I hope that that's what we are. But beyond that, there is not much specific guidance. Kiowa does not identify further requirements or qualifications for you to be board members. So that begs the question, where do we get these requirements? Where do we find these qualifications? And for each and every one of you, the answer is going to be your association's bylaws. Your bylaws should have a section in them that is something to the extent of a paragraph called qualifications for boards. I'd say from all of the community association documents that I've seen, there is a baseline that they establish, which is that associations at least require you to be an owner within the community. Why would you want to appoint me to be your board member in your association? Why would you vote for me? I have no vested interest in that. Each and every one of you do live in the community. They know, you know about, or at least, you're an owner within the community. And that gives, that's an important baseline for virtually every community that I've seen governing documents for. Other associations might have an additional requirement, such as that you have to reside within the community. Now that works for some communities. It doesn't work for others. Think of the example I often use is, what if you have a second home in a ski town up in the mountains, some condo complex there at the base of the ski hill. Not a lot of people live in those condos year round. They're vacation homes. So if you had a requirement like that in your bylaws, you wouldn't have a sufficient enough population of your community that could serve on a board. So keep that in mind. If your community has difficult to operate within requirements to be on the board, your board should consider a process by which it can amend those requirements and make it so that you open the door to other people that are interested in serving in your community on your board, to allow them to actually be on the board by loosening those qualifications. Other situations, you certainly might want to tighten them up. That is a case-by-case, community-by-community basis that I leave to you guys to all consider. Finally, we do see a lot of times that board members have a requirement to be in good standing. This usually means that you're up to date on your assessments, that you are otherwise in compliance with the association's governing documents, your covenants, your restrictions, that you're not the one out there breaking the rules every day. I think that if the community knew about that in the first place, they maybe would not be less inclined to vote for you to elect you to the board, but I can't speak to that. So look at that and think about if that requirement is an important requirement for your communities. And if so, consider implementing language to that extent. But ultimately, review your documents carefully. And I also encourage you at your board meetings to identify what your requirements are, what the qualifications are to be a board member. And if you have that, then you're going to be in good shape, I think, in the long run. All right. Board member compensation. This is another question that we hear a lot about here in the HOA Center. Can boards get paid for their services? The baseline rule comes from the Colorado Nonprofit Corporation Act, and it allows for board members to receive compensation. But, and this is an important but, your association's governing documents must expressly allow for compensation. And I mentioned before, I see a lot of governing documents. The vast majority of associations in the state of Colorado and elsewhere call for an association to not have excuse me, forgive me. They call for what we say is a volunteer board. Some specific things that I would encourage you to think about. Are you allowed to receive a direct compensation based on your governing documents? That would be something like an hourly rate or a monthly rate. Can you receive indirect compensation? And my example there would be, what if you are a lawyer and you're on the board? What if you're a plumber or a landscaper or an electrician or a community management company? What if you provided those types of services? Can you also provide those services to your community while serving on the board? So that's indirect, because it's not, the board's not paying you probably, but rather paying your plumbing company or your electrician company. So that's an indirect compensation. Check your governance policies to see if that type of payment is allowed or not. Another really important question that we hear a lot about is, can I be reimbursed for my expenses? You might go and buy a cheese plate for the annual meeting, or a flat of water, or something like that, and because you're doing it at the last minute, you don't have time to get the treasurer to issue a check and whatnot. So you just put it on your credit card, and then you're going to ask for a reimbursement later. Most of the time, that's okay, but I do see a lot of times when we have limits on that. Reimbursements might be limited to a maximum of $50 on an annual basis or a quarterly basis, or per incident, or something to that extent. Consider that, and also to avoid abuse by the current board or future board members, think about if you would want to limit that, so that you don't get someone that goes and spends hundreds of dollars on something just so that they can get the credit card points or miles or whatever. And then it's because it's also harder. There's an added accounting and tracking process that you'd have to go through as a board to follow that money and make sure that that money is being used properly and for the purpose that it was intended. So consider that. Now, this last one is one that interestingly just came up somewhat recently with me here, and the community had some really interesting language that that made it a challenge. But what if you as a board member say, hey, guys, we maintain our roads and we plow our sidewalks with this ATV maybe that's owned by the association, or we wash the decks, the walkways that are outside quarterly or monthly. But you know what? We want to get a new power washer, so we want to sell this one. It's still worth money, so let's sell it. Can we sell it to a board member? Can a board member buy it? Check your governing documents to see if you can do that kind of business with the association, because you are a board member. And always remember, look back, take that step back and say, what's this going to look like to the unit owners? What's this going to look like to a judge? Did I pay fair market value? Did we maybe post it on Craigslist and we received five offers at $25, but guess what? The board member offered $30. that's the best deal for the association. Maybe that could be reasonable. That could be okay. But it's only okay if your governing documents allow for it, and that it doesn't constitute a conflict of interest. But if the fact pattern's different and you have 5 offers at $25 and the board member offered 20, and guess who wins at with the $20 offer? That's probably going to look very bad to your community. Avoid these issues as much as possible so that you don't find yourselves going down a road which ultimately can turn into a very costly and very frustrating and very emotionally charged legal proceeding, simply because you're looking for a get a good deal or help out your buddy. As a fellow, you help out your fellow board member. Keep these things in mind. What is it going to look like to your unit owners that aren't your best friends? What's it going to look like to a judge? So, and this is an important caveat. The final line of this slide is very important. Always keep in mind that if your association is going to compensate board members, you should A, check with your attorney, and B, check with your insurance agent. See if this compensation plan that you're discussing is going to affect your coverage or is going to affect legal liability for your association. Remembering that most of the time, direct compensation isn't common, indirect compensation isn't too common, but these expense reimbursements and certainly the purchase and sale of personal property, they might happen a little bit, they might come up a little bit more often in your community. Keep it in mind and get the professional opinions from your insurance and your legal counsel so that you have a backing to support these decisions. Legal liability for board members is talked about specifically in Kiowa at section 303. And it does protect you as board members from personal liability, but that, of course, gotta love the law, there are exceptions. If more than likely than not, the vast majority of the people that are on this call today are not appointed by the declarant. But if so, you're required to exercise the care of a fiduciary of the unit owners in that situation. Most of you, though, are not appointed by that declarant. And so the rule there is that no member of the executive board and no member of, no officer shall be liable for actions or taken or omissions of actions that are taken in the performance of their duties unless you have acted willfully and wantonly. And that is a legal term. I can't tell you exactly what that means, but think about those words and that word, those, and I think you're 95% of the way there to understanding that terminology. An important consideration for you is insurance policies. Many of you might have officers and directors insurance, O&D, in addition to the other required insurances of general liability for your community. Talk to your insurance policy providers, talk to your insurance brokers, see what that would cost if you don't have it. This will give you significant peace of mind so that you can conduct your job, that you can exercise your judgment in conducting business. Colorado recognizes something called the business judgment rule. And so that grants you a lot of deference and it protects you as board members from a lot of claims. However, it is not it's not an impenetrable wall, and that this language is proof positive of that. If you are willfully and wantonly acting or omitting to act, maybe it's not enforcing your governing policies, not enforcing your covenants, maybe God forbid, discriminating against one of your your community members because of their race or religion or age or gender, etc. Any suspect class, you need to be mindful of that. You are not you are not clear to do whatever you want as board members. You do get deference, and a judge will give you that deference, but it is not rock solid. When we're talking about the liability of board members regarding the investment of reserve funds, which is an important and rather hot button topic in the state of Colorado right now, the Kiowa merely states right now that those duties need to be exercised in good faith, with the care of an ordinarily prudent person, and in a manner that is believed to be in the best interests of the association. Right now, we don't have rules about what you guys do with your savings, with your reserve funds. Some of you might have brokerage accounts if you're lucky enough to have reserve funds that are big enough, rather than just a savings account that pays whatever, 1% or whatever. You can do that, but you have, and you are also allowed to rely on the professional opinions of financial accountants, financial brokers, financial advisors, but you still are responsible. You need to be exercising in good faith. Something to pay attention to in years to come. We might see laws that change this, that enhance this, that limit this. We do not have those laws in place now, but I encourage you all to keep your ear to the ground. Visit our website so that you can see if new laws are coming down the pike in years to come that may expand or restrict this right and this protection that you see and that you possess right now as board members. Time commitments for board members is the last important thing I'd like to talk with you all today, and then I'd like to take some of your questions. So if you do have questions, please, while we're coming to a close here, I encourage you to put some questions into the chat if you like, and I'll look forward to speaking to some of those questions in just a few minutes. But excuse me. So time commitments really do vary based on the age of your property, the size of your property, the types of amenities that you have, the number of units or parcels that you have. If you're in a high rise or on a ranch that is 1,500 acres versus a 6-unit property on one street down a public street near downtown Denver, that's a big difference. What you're going to have to do if you're managing this on your own, you're walking around the property, looking for violations, understanding what's going on, approving and disapproving architectural variances, all of that has a lot to do with how much time you will have to commit to your board services. We always recommend you should assume that it's going to be a few hours a week at a bare minimum, even for the small communities out there, even for the communities that don't have a pool and a clubhouse and tennis courts, etc. It's invest that time so that you can stay ahead of your problems. I always encourage board members to find dates and times where the board can work together, where you can have formal meetings that work for everyone. And yeah, I might get sent on a trip for work. That's okay. Maybe you can attend meetings electronically from the hotel room after your day of work when you're remote. That's okay. You can work around some things, but communicate with each other and come up with a plan and try to stick to that plan as a board. And finally, self-managed communities, this is important. Many CAMs out there, they've got an emergency line, or you call in their main line and hit 9 for an emergency because you got water coming through one of your unit owners' roofs, or someone's stuck in the elevator. But if you don't have a CAM that you can turn to because you're self-managed, consider the amenities in your community and consider having a list of emergency contacts, emergency vendors for those foreseeable emergencies. And I just mentioned 2 of them, but they're also here in the words. an elevator breaking, in a major leak, your boiler's not working, so no one in your community has hot water right now. Um, Save yourself some time, save yourself some concerns by talking this through with your board and preparing a list for your board so that if an emergency arises, that you can jump on it, that you can address it. Be prepared. I'm an Eagle Scout. I was a Boy Scout when I was a little kid, and I'm an Eagle Scout today. Boy Scouts are their motto is be prepared. That's it. Sage-like advice for all of you as well. You know your communities better than I do, better than other people do, so you know what might happen, what could happen. You there and you don't have to be prepared for every single thing out there, but be prepared for as many of them as you can be. There are a lot of them, that are foreseeable. So kind of closing up here, I just have a few more what I call pro tips, some hot takeaways for you that I'd like you all to be aware of and remind yourselves of. That you have a duty to maintain a complete record of all board actions. This can be done through accurate minutes, accurate resolutions of the board, but you also need to save all emails between your board members as well as those between your board members and unit owners. You have document retention requirements by statute, as well as you might even have more enhanced document retention policies by your own governance governance policies. Follow those so that you can provide documents when requested and also revisit those documents when you need them as well. Maintain complete written records of all your financial transactions. Self-managed document or associations, that doesn't mean that the board has to do everything on their own. I find myself saying a lot to people, you're not expected to go cut the grass. You're not expected to re-roof the building, to get up there, clean the gutters. Colorado allows you to contract with third parties, and this is that hybrid management again. It's acceptable, it is legal, and it's in some cases might be a great idea for you all. What the law expects and what your community members should expect from you is that you know what you can and can't do. Don't try to take on tasks that are outside of your skill set. I'm not saying don't try to learn something new. I would never in a million years suggest that to you, but know your limitations. Know that if you guys don't have accounting software that you know how to use, don't try to do your own accounting. If you're running a community of 1,800 units, for instance, or something like that, know your limitations and act on those limitations. Okay, and then finally, know what you need and know when you need to reach out. This just furthers my previous point. You can consult with lawyers and accountants and insurance brokers. They are experts. You can justifiably rely on their advice, their expertise, and as long as it's reasonable and you can act on that, that's okay. That's within your right as a board member. But more importantly than sometimes these third parties, use the resources that you know of within your own community. That's important as well. Know that you can form committees. Know that maybe it's an architectural review committee or communications or a newsletter committee. A fire mitigation committee would be a brilliant idea for many of your communities out there. Think about what you can do to impose new rules within the community to enhance the safety should the worst things imaginable happen in your community. If an ounce of prevention now, a little bit of work by a community committee now could save so much hurt and loss in the future. And my final and most important rule is, just because your community has done something a certain way in the past does not mean that it's the right way to do it. it's definitely not the only way to do it. Things change in your community, and your board should be cognizant of those changes and should consider how, as those changes take effect throughout your community, that you are able to adjust appropriately. Maybe that's updating your governing documents because the new laws just came out 2 days ago. Maybe it's changing something else to allow or disallow short-term rentals. But make those changes. Make that first off. Create your vision and share that vision, and then you can propose those changes, and then you can effectively communicate those changes so that everyone in the community understands where we are. I always want to encourage you to visit our website.